I was elected. The judge was appointed.
Wow, somebody who thinks he's that powerful and has that much right to bury people's, democratic rights?
You better start asking yourself some questions about how the hell did this thing get in our Constitution?
I will trust that Ontarians will reflect on whether or not the provincial government made the right decision on overriding the Charter of Rights and Freedoms.
The Constitution and the Charter are fundamental institutions in Canada, and they should not be played with lightly.
Ontario Premier Doug Ford's decision to invoke the notwithstanding clause has prompted no end of political reaction. Much of the debate involves why and when Section 33 of the Charter should be used. Is there a bar that has to be met? What is the purpose of the clause if it's rarely used? And what are the repercussions for the country's judiciary if it is used more frequently? Time to hear from those who know about sitting in the Premier's chair. It's time for Premier's League. And joining me now, former BC Premier Christy Clark, Senior Advisor with Bennett Jones. She's joining us from Vancouver. In Calgary, Brad Wall, former Premier of Saskatchewan, now Special Advisor with Osler, Hoskin and Harcourt LLP. And in Montreal, former Quebec Premier Jean Charest, partner at McCarthy Tétrault. Nice to see you all. Thank you so much for joining us. I really appreciate it.
Pleasure.
Ms. Clark, I'm going to start with you. Do you agree with Premier Ford using the notwithstanding clause for a law to reduce the size, basically, of Toronto City Council?
Well, I support the use of the notwithstanding clause. The highest court in the land in our system is not the Supreme Court. It is the elected Parliament. And the Section 33 was in the Constitution. We wouldn't have a Constitution without it, by the way, recommended by that incredible radical Peter Lougheed. It's there so that elected parliaments who are accountable can, when they see it's necessary, be a check on the courts. And that's what Section 33 is all about. I think it was an appropriate use of the power. And I actually think it's a good thing for Canada because we are in a moment where Canadians are looking around saying, hey, why can't anything get done? Well, Premier Ford has shown there is a way to find a way to get things done in spectacular fashion. And I think he did the right thing.
Okay, Mr. Wall, I have to ask, do you agree?
I do. It's been my experience, certainly was my experience in the province of Saskatchewan, that Section 33 played an important role in ensuring school choice. Just last year, a judge ruled on a question, a legal fight between our separate school board and the public board. And the net result of the ruling would have been to risk the separate school system, to risk the ability of the government to provide some funding to private schools, to some faith-based schools, but significantly we wanted to ensure that parents had choice for their kids in terms of separate public and all of the options, and that the government had the option certainly and the authority to provide some financial support as well, some funding. And so we passed the School Choice Act in our province. We introduced it with Section 33 as a part of it. This is an important tool for premiers, as Christy has just canvassed quite effectively. I think it's, I've seen on my Twitter feed and some social media, I've seen people worried about the rule of law in light of what Premier Ford has done. Let's be very clear. Section 33 is part of the Constitution. And so the availability of the notwithstanding clause to premiers is very much a part of the rule of law. It's also a part of a check and balance we have in terms of the judiciary and the elected legislatures in the Parliament of Canada.
I think, Mr. Charest, that perhaps some of the people who are at least raising concern over the rule of law are basing that concern on Premier Ford's statement that he is elected and the judge is appointed. And I'm wondering what you think about that, and then, of course, love for you to weigh in as well about what you think about his use of the Section 33 right now.
Well, in Quebec, as you'll know, Veshi, the notwithstanding clause has a long history. And I agree with both Christy and Brad that it's in our framework of our laws and the Constitution. So the rule of law is not brought into question here. It's all legal. It's all provided for. And it was done at the great request back in the early 90s of the premiers out west, Blakeney in Saskatchewan and Lyon in Manitoba, and Peter Lougheed. And Christy's quite right. We would not have the Constitution had that Section 33 not be written in. Now, that being said, the real issue becomes, is it justified in the circumstances, which is a separate question. And in my experience, and we've had to deal with this on language legislation on whether we should stop women or vote laws that says that people should not wear headwear or any religious symbols. And what I found is that if a government's going to invoke the notwithstanding clause, there has to be empirical evidence politically that justifies doing so, that it should not be done in an arbitrary way. And by the way, it's designed in that way so that if you do invoke it, there is an onus on your shoulders politically to demonstrate to the public that you're using the ultimate weapon to establish legislation, and you have to have a clear rationale for doing it.
That's a really interesting point. Let me pick up on that for you, Ms. Clark. Do you think in this case that bar has been met?
Well, I think it's up to the politicians to decide that. It's not a legal question. It's just a political question. And I mean, if I was to put myself in Premier Ford's shoes, I might have made a different decision about this. But I mean, I'm guessing he made the decision because there is never a good time to reform municipal government. And if he didn't do it now and had been dragged through the courts and waited 3 years, it will never happen. If it was a priority of his, I mean, as Carolyn Mulroney said, I don't think there's ever a good time to do these things. And it isn't up to the court to decide when the time is. It is up to the politician, the Premier, who is going to be held accountable for that. And Premier Charest is right. The notwithstanding clause, there's a standard for using it. But it's a standard that's a political standard, and it's politicians that need to make those decisions about whether or not the politics of it is good or the politics of it is bad.
And to Jean's point, then the politicians will be held accountable by the people. The people will ultimately decide whether or not they believe a premier or a government has used the notwithstanding clause in a responsible and important way, and that's also how it should be.
What about the fear, Mr. Wall, though, that this sort of sets some kind of, I mean, and again expressed by Premier Ford's critics, that this perhaps sets some sort of new standard for using it in the future, and that we could see that bar that was defined by your colleagues, lowered in the future because of this?
Well, I don't think we have defined the bar. As Christie's just said, these are political decisions, and so the bar is set every time a decision like this is taken. I don't think it sets a precedent. I mean, obviously, this is a tool that's rarely used, and that's been its history since it was included in the Section 33. And so I think folks should relax a little bit in terms of worrying now that this is going to be a regular occurrence. I think that if there are judgments that are made that are subject to notwithstanding clauses, not all the sections, some of the sections of the Constitution are not subject to the clause, but to the extent that judges are ruling, one of the measures of accountability hardwired into our system, and I think it's a positive thing, is the accountability of the judiciary to the people, to the respective legislatures and the parliaments. But I'm not sure this is a precedent, and we're going to see now a torrent of the invocations of the clause.
What do you think about that, Mr. Charest?
Well, I agree with Brad. I mean, the clause, using the clause in itself is exceptional and unusual because it's so rarely done. And each premier has to determine whether or not the circumstances justify the using of the clause, and whether they want to carry the onus of using the clause, because there is a political onus in using it. And just to remind our listeners, it has a 5-year time limit. After 5 years, the clause, it has to be renewed. And so that also was part of the thinking of using this clause and making it difficult for politicians to use the clause, because they wanted to protect the fundamental rights that are enshrined in the Constitution. So it's going to be unusual. Whether this case, it's all very much a political call, Vashi. It all depends. And both Brad, Christie, and I are far away from downtown Toronto. For years, though, we've all heard how difficult it's been to manage the city of Toronto. And Premier Ford is making a very real judgment call in regards to how firm he wants to be in sending a signal that he wants change at City Council.
Okay,
and quickly, I think there is. But I think it's worth noting there is one other political consideration here that hasn't been noted much by the media. Premier Ford is answering this question that many people are asking: who's in charge in our country? Are the people that we elect elected to get things done and get them done quickly and efficiently so we can have things like Trans Mountain and other national projects go ahead? Or are there people who are unelected and ultimately far less accountable? Are they the ones that are in charge? And I think Doug Ford is actually answering that question in greater detail than he is even the question about the cost of government in Toronto.
Okay, we're going to pick up on that point on the other end of this break coming up. We'll be back with the Premier's League right after this. We are back with the Premier's League and our discussion on the Ontario government's use of the notwithstanding clause. Former BC Premier Christy Clark, Brad Wall, the former Premier of Saskatchewan, and former Quebec Premier Jean Charest all join us. Thanks so much again. Ms. Clark, I'm going to pick up on where we left off before the commercial. You were saying that Doug Ford is making a point sort of about the effectiveness or how effective elected leaders should be versus others. I'm just wondering, though, are you pointing to the judiciary in what you're saying?
Well, no, I mean, I do know that things can drag through the courts for a long time, but I also know, and the courts are vitally important as a pillar of our democratic process, just like the media is and parliaments are. There's no question about that. But the Section 33 was put in the Constitution as a way to ensure that the ultimate voice is one that's setting public policy in this country, is one that is accountable to voters every 4 years. And the courts are not that body. So I would say, in recent years in particular, we've seen the courts be more adventurous in terms of moving into areas of public policy, which I think are more properly the areas for politicians, the things that people run on, get elected on, lose elections on.
Although I'll say that Mr. Ford did not campaign on this.
Well, no, but I think most of the people that support Doug Ford probably also support smaller government. And I mean, I'm not going to make a political judgment. I don't know what he's seeing, what he sees politically out there. But I do know, and I do expect now that the Section 33 has been invoked in Ontario, you may see more of it from provinces as courts continue to move into areas of public policy where I don't think they should properly be making laws. I think you're going to see perhaps more legislatures move in and decide they want to, as the accountable bodies, exercise their role as the highest courts in the land.
In this instance, Mr. Wall, the court or the judge in this case didn't say that the province couldn't do this. His ruling was based on the timing of it, essentially ruling on the idea that, or presenting the idea that they tried to change the rules in the middle of the game.
But de facto, the judge tried to stop the government from doing it.
For now.
Had it not been for the clause. Well, I think it's a point of fact that his ruling would have stopped the government's legislation from moving forward or being enacted. And I didn't, in May of 2016, in the spring of 2016, I also didn't campaign, even though the court case that resulted in us using the notwithstanding clause to protect school choice, I didn't campaign on the fact that we might use it. A year later, we did. And so that's the nature of these issues, of these decision points. It's typically, the ruling will happen from the judge, and it may be nothing. The issue at hand may be nothing that was contemplated in an election platform or in an election period, but the Premier and the government of the day and in the respective province are confronted with the decision and then have the option to use the clause.
Did it weigh on you? I mean, the sort of, was it a big deal, a big decision for you to make as Premier when you decided to use it?
No. What was a big deal for our government was ensuring there was school choice for Saskatchewan families and for students. That was the big deal. I slept very well the night we made the decision and the announcement.
Mr. Charest, what do you think about the sort of debate going on about are judges going too far? Are they wading into territory that they shouldn't? Or is some of what's going on right now an attack on the judiciary?
I don't see it as an attack on the judiciary. By the way, I'm sure that both Christy, Brad, and I, when we saw this thing unfold, because of our experience as premiers, were all thought immediately, if there's one thing that's clear when you're the premier of a province and you head a provincial government, it is the provincial governments who have full control over the way municipalities are organized. And some people may not like that, but that's the way it is. So I was surprised by the ruling, frankly, because the legal foundation for acting on behalf of the government of Ontario, in my mind, was very, very clear. Now, After that, it becomes very much a question of political opportunity and whether or not you want to use the notwithstanding clause in those instances. Do judges go too far? I don't think they do in general, but you know, when it was thought up in 1981, there was probably a reason for that. Christie alluded to it very early on. We elect people. The parliaments are ultimately sovereign, and that's the highest court in the land is still our parliaments, whether it be provincial or the federal parliament, and the notwithstanding clause is a tribute to that.
Ms. Clark, there's some speculation, or at least questions, going towards the Prime Minister right now. Are you going to get involved? Are you going to wade in? What do you think of those questions, and what should the federal government be saying from your perspective?
From my perspective, I don't think the federal government has a role to play in this at all. It's exclusively provincial jurisdiction, as Jean pointed out just a moment ago. And if I was the Prime Minister of Canada, I wouldn't go near this with a 10-foot pole. But I would also say, though, it will raise the question for the Prime Minister, further to what Premier Notley's been saying, will he be prepared to use some legislative hammers that are at his disposal to make sure that Trans Mountain goes ahead? That recent court decision on Trans Mountain had a lot of people confused, and it slowed down the process significantly. Prime Minister, I think, will now be pressed quite properly on whether or not he's going to use some version, some legislation as heavy-handed as Section 33 might be, or even Section 33 itself, to make sure that we can get a project as nationally significant as Trans Mountain is off the drawing board and shovels in the ground.
Mr. Wall, what do you think about the questions towards the federal government about weighing in?
Well, I agree with Christie. I agree that she'd make a great Prime Minister of Canada, and I also agree that if she were in that role, that she would stay out of it, as this Prime Minister should do. This jurisdictionally, this is none of his business. The Trans Mountain is very much, obviously, the federal government's business, not just because, you know, they had to go full Venezuela and buy the pipeline, but these are federal approvals for the pipeline that are at risk in that question. So I think in this particular issue, Premier Ford has the jurisdiction, and as Jean has pointed out, also very much has the authority. He's got history behind him in terms of the provinces being able to weigh in, being able to provide direction in terms of the organization of municipalities.
Mr. Charest, final word to you.
Well, Mr. Trudeau should stay away from it. Both Brad and Christie really nailed it. I mean, this has nothing to do with the federal government. There was this argument that they should invoke the disallowance clause, which is an old clause used for the last time in the 1940s. That would probably be illegal. So no question there, he should stay away from it. And Mr. Trudeau has other things on his plate, as pointed out by Brad and Christie. He doesn't need to get involved in this issue. He has plenty of other things to worry about.
Okay, I'm going to leave it.
People have said that this is a constitutional crisis. It isn't. If he were to use that measure that Jean's just alluded to, that would, I think, cause a constitutional crisis.
To be fair, he's pretty much tried to say, I won't be doing that. So, but thank you very much to all three of you. Thanks to our Premiers League, former BC Premier Christie Clark, Brad Wall, former Premier of Saskatchewan, and former Quebec Premier Jean Charest. Appreciate all your time. Thank you.
Thank you.
Thank you.
Thanks very much.
Bye-bye.